All rise. Court's in recess.
I don't know who that is. It's Rick Black. Rick Black. Ain't supposed to see her.
All rise.
Thank you. You may be seated.
Court's back in session.
All right, I went to go and get your computer, Mr. Ross. That's the first order of business. I want that to be on the record that I am presenting Mr. Ross with his computer. It was brought to me last week, but we were waiting until this hearing. Now you have it.
Thank you.
All right. And it has only, by the way, been in my possession. Nobody else has had it. All right. Since it was returned from Mr. Gallant. Now we may proceed. We are here on the record and on the matter of Tonya Barina versus Netflix, Inc., cause number 2021 CI 04501. Mr. Dedman, I'll allow you to proceed, and then we'll take up any other matters.
I did not know what order you wanted to take the motions, Judge. I'm here on a motion to enter the judgment, which conforms with the jury verdict. I know Mr. Ross has filed various motions about a judgment notwithstanding the verdict. So
Okay. All right, Mr.
whichever
Ro-
order you want to hear it, Judge.
All right, well, I'm ready to enter the judgment that corresponds with the jury's verdict. Have you had an opportunity to review it, Mr. Ross?
Yes, I have, Judge, and I submit that the plea to the jurisdiction that I filed, together with a supplement to the plea and evidence that I proposed to admit this morning or offer this morning with regard to fraud and fraudulent concealment that we discovered at trial and post-trial, where the plaintiff falsely or fraudulently testified that she started receiving hate mail on March 11th, 2020, when the documentary was published by Netflix. However, the evidence in the record, although it was concealed as to the dates, revealed that Ms. Barina started receiving reactions to the documentary in January, February, and March 2020, before the document was aired, or the program was aired on March 11th, 2020. And in view of that evidence, it shows the illegality of not only the pleadings that were filed by the plaintiff, but also her testimony and evidence that demonstrates an opportunity and a necessity for me to get leave to amend our answer to include an affirmative defense of limitations. The third amended petition that was filed by Mr. Cobb and Dedman stated that the episode, which aired on March 11th, 2020, was the basis for the defamation claim. That is a judicial admission that the statements that were made by myself, Ms. Rivera, the Martinez family, prior to March 11th, 2020, were not the subject of this defamation claim by Ms. Barina. Her testimony that the documentary aired on March 11th, 2020, when she started receiving phone calls in the middle of the night and hate mail, was false and misleading. Her evidence that is attached to as Exhibit 11 of plaintiff's trial exhibits on March 2020, before she says that she started receiving mail. Now, we weren't able to find that evidence because Ms. Barina, in her testimony, admitted that she had prepared Exhibit 11 and provided it to her attorney. And we discovered that the dates that were printed, I have the binder, are illegible. You can't read the dates without a magnifying glass or appropriate lighting, and the jury never actually got to see the dates on the evidence that shows that Ms. Barina started receiving written responses in January, February, and March.
So the program aired on what day?
The program aired in January, according to Ms. Barina's Exhibit 11.
That is incorrect, Judge.
It also aired in February. And
That is
it
also
aired
incorrect.
prior to March 11th. And the way we discovered that was by reviewing plaintiff's Exhibit 11 with a microscope and discovering the dates on the hate mail that she started receiving months before she said the documentary aired. Now, her third amended petition states that March 11th, 2020 date was the operative date for her defamation claim. So she missed the deadline by over a year to file a defamation claim against myself, Ms. Rivera, and the Martinez family for our statements that were published to the Netflix producers in 2019. She waived any opportunity to collect any defamation damages from those statements. And the court will recall that the focus of the trial was the guardianship proceeding and all the string of exhibit after exhibit of hate mail that Ms. Barina received after March 11th, 2020. So just to show how much prejudice was caused by the way the trial was presented, after the court said you were not going to allow relitigation of the guardianship proceeding, the jury awarded $3.5 million.
No, you can set that up, but if we have a closing today, you got to go to it. But I'm still waiting to hear back from the title company of what to do.
You did. I didn't know who that was. All right, go ahead.
The evidence of how prejudiced the jury was by the presentation of evidence at trial is reflected in the damages awarded against me. $2.5 million for 3 statements that I published in the spring of 2019 in interviews with Netflix producers. The first one, I believe it was a crime. There's no context to this statement except in the documentary, which was over a year after I published that statement to the interviewers. I cannot be held responsible for the context that Netflix positioned that comment in their documentary, which, according to the plaintiff's claims, the gist of the program was that Ms. Barina was a criminal, that a crime had been committed, and that somehow the gist of the program was that Ms. Barina had committed a crime. Well, when I said I believe it was a crime, I wasn't referring to Ms. Barina. There's no evidence of what I was even referring to as a crime. But the jury was presented with that isolated statement for which they awarded about $1 million in defamation damages. The next statement was the guardianship proceeding is a textbook case of guardianship abuse. Now, the way that was presented in the documentary was I referred to a state agency filing a guardianship action, and the case being presented in Judge Rickoff's court, and court-appointed psychiatrists reporting that the proposed ward was totally incapacitated. I didn't refer to Ms. Barina in the documentary with regard to that statement that it was a textbook case of guardianship abuse. And there's no way for the jury to conclude that I was referring to her. I was referring to other, but when the plaintiff isolated that statement, I believe it's a textbook case of guardianship abuse in the jury verdict form, it made it appear to the jury that somehow that was connected to Ms. Barina's appearance in the documentary, other comments that were included in the documentary, but not my isolated statement. And the jury awarded about $1 million in defamation damages for that statement. And then the third statement was, there is evidence that Charlie is in a guardianship that is against his interest, and that the people who have been appointed to manage his estate have exploited it. That's a statement that there is evidence, and the court and the jury heard days of evidence about how Charlie's estate was exploited by the people who were appointed to manage it. And it wasn't focused just on Ms. Barina. It was focused on myself, Ms. Rivera, Ms. Martinez, and others in her family, alleging that they exploited Charlie Thrash's estate. Now, that statement that there is evidence is true. There was evidence on both sides. Whether the evidence was true or not is inconsequential. My statement was a statement of fact that was true, that there was evidence of that Charlie was in a guardianship that was against his interest. I was sanctioned $1 million on the verdict form. How can that possibly be fair and just? There was no evidence of my ability to pay except for the evidence that I had been sanctioned by Judge Kazin in 2019, $300,000 that I had not paid. Obviously, either there was no attempt to collect or I didn't have the resources to pay that sanction. So how can a $3.5 million verdict against me or judgment be fair and just? I mean, that would saddle me and my heirs for forever, based on the total lack of evidence of my net worth. Now, I think the court needs to consider the plea to the jurisdiction in order to determine whether this case was even filed within the statutory deadline. And in order to do that, because myself and the other defendants were blindsided by the plaintiff's concealment and false testimony at trial as to the date when this defamation publication started. And so I filed yesterday a motion for leave to court to amend my answer to include an affirmative defense of statute of limitations. And that would apply both to the 2019 statements, which the plaintiff has judicially admitted are not part of their defamation claim, as well as the 2020 publication by Netflix.
All right. Mr. Dedman, how do you respond?
Thank you, Judge.
I have one more point, and I'm not going to go through it all, but Joanne and I filed a motion for judgment notwithstanding the verdict. And the pleadings before the court are voluminous, and I can't expect the court to read them and digest them and make conclusions in this hearing. I don't think there's enough time in this day to go through all the evidence and the pleadings that we filed in support of our motion for judgment notwithstanding the verdict. But I submit that it is important for the court to make an appropriate judgment, that you have to consider all the case law and legal authority and all the facts and legal argument that's presented in these documents, and there are hundreds of pages. So I would request the court take the matter under submission, including, and not jump the gun and rule on the motion to enter judgment on the verdict, because it would be reversed on appeal. I'm very confident of that based on all the argument, evidence, and legal authority that I've researched. Thank you.
Thank you, Ms. Rivera. Since this is your joint motion?
Yes, ma'am.
Okay, do you have anything to say?
Not so much regarding that. I did find new evidence that I think part of the confusion was that we were all treated as one and not individually. So there was a little time delay in when I got to review some of the evidence. I had to wait kind of my turn, which is when I was able to dig up some of the dates and things like that. And then my understanding was that it was about the Netflix documentary, but it really turned into the guardianship issue. And then somehow it was Netflix, but then my Facebook page got included, although was not part of the original filings. So there's a lot of confusion.
But with respect to that matter, your Facebook postings were part of the defamation claim. It wasn't just the Netflix documentary. Is that correct?
They included them, but that's not how it was styled. But
okay, I understand. All right.
I have one last point, Judge, that I can't neglect. The jury answered one question, no, in the whole verdict form, and that was whether there was a conspiracy between myself, Ms. Rivera, and the Martinez family and Netflix. And the jury decided there was no collusion or conspiracy between Netflix and us. And because all the statements that were listed in the jury verdict were republished by Netflix in their documentary without any participation by ourselves, we cannot be held responsible for Netflix damages because there was no conspiracy between us, and the jury answered that question in the negative.
In the negative.
And I think that's critical to the outcome of this case.
Okay, thank you. Mr. Davis?
Judge, do you have a copy of the response that we filed?
I do not.
May I approach?
Yes. I don't have it in front of me, but of course it's on Odyssey.
Do you wish me to stand or sit for the court reporter with the microphone?
You can sit for the court reporter. It's easier for her.
Judge, the only two motions that you've heard of this morning are the motion to enter judgment and then a judgment notwithstanding the verdict. First of all, if it's a judgment notwithstanding the verdict, the court doesn't get to hear new evidence today that may be the subject of a motion for new trial. The court can only decide on the evidence that has been admitted.
Yes.
That would include the record in the court's file, and we request that the court take judicial notice of the file.
Yes.
When you see the Facebook posts that they complain about, all of this came up in the anti-SLAPP motions that were filed by Mr. Ross, Ms. Rivera, all of the Martinez defendants, and Netflix. In that, and the evidence presented by Mr. Ross himself, were newspaper articles published in 2019. It's those newspaper articles which brought the initial response to Ms. Barina and the complaints in Plaintiff's Exhibit 11 that they complain about, not the publication of the Netflix episode. In fact, the date of the publication of the Netflix episode has been judicially determined by the Court of Appeals. May I approach?
Yes.
As the court is aware, when you file an anti-SLAPP motion, the burden then becomes on Ms. Barina to present clear and convincing evidence. Not just preponderance of the evidence, clear and convincing. Judge Stryker found that the anti-SLAPP motion was not viable, and they appealed it to the Fourth Court of Appeals. And what they have to produce by clear and convincing evidence are each of the standards of defamation. That is, that there's a publication of a false statement of fact to a third party, the defamatory statement was concerning the plaintiff, there was a degree of default, and damages. All of that was proven. With Mr. Ross's statement, I'm confident that the Court of Appeals will overturn this verdict. He's confident every time he goes to the Court of Appeals and hasn't won one yet. If you have a look at the Netflix Inc. versus Barina by the Fourth Court of Appeals, it's an August 22 decision, which they attempted to take to the Supreme Court, and the Supreme Court didn't want to hear it. If you go to page 6 of 13, the Court of Appeals found the episode which aired March 11, 2020. That date has been determined and is in the record. So this argument that no, it was published at some other date is all baloney. That's been determined and was determined in the anti-SLAPP motions. With regard to their argument that they now want to do a trial amendment on limitations. May I approach, Judge?
Yes.
I see what you're giving him.
Yeah.
Thank you.
I was presented with this same argument in the case of Meza Burns, which ended up before the Fourth Court of Appeals here in San Antonio, and it will tell you that limitations is an affirmative defense, and Rule 94 requires that affirmative defense be raised before trial, not 5 years after the pleadings have been on file, before trial. It does go through the argument under Rule 63 that the court does have discretion to amend the pleadings. However, in this case, where it's a new substantive matter, they do not. The proposed amendment would introduce a substantive matter, that being a new affirmative defense, that would clearly prejudice the plaintiff in this case, because it's now been raised after the close of evidence and should not be allowed. There are several cases on that point.
I also do not believe that the limitations matter can come up at this stage after trial. That
That's-
is in fact an affirmative defense that would have had to have been raised prior to trial, and the court would have needed to have ruled on that limitations defense before trial.
And that's in fact the next case I was going to give to the judge, which is Thomas v. Graham Mortgage, which found that after the plaintiff has rested, it would be clearly prejudicial to plaintiff to allow an amendment for a new defensive matter or a new cause of action, and should not be allowed.
All right. With respect to, with respect to that matter, with the limitations, that is overruled and denied.
Your Judge,
Then with,
we have evidence to support the discovery of evidence that was presented at trial that was fraudulently concealed as to the dates.
Let me speak about that, though.
Beg your
Okay.
pardon?
And let me speak, I haven't gotten to that part yet.
Well, I believe it's relevant to the issue of whether we should be granted a trial amendment to assert affirmative defense as to limitations even after the plaintiff rests, because that was when we discovered the fraudulent concealment, which prevented us from raising that issue prior to the trial.
Okay, well then, but things have to happen procedurally. When I say they have to happen in the correct order, procedurally.
And before judgment, I would submit, is the milestone that has to be, that the motion for a trial amendment has to occur before entry of judgment.
Now, with respect to your judgment notwithstanding the verdict, you have raised issues for the court regarding whether or not the verdict could support, or whether or not the jury could have reached his verdict based on the statements that you made and in the context that they were made. And you'd like for me to review those matters and not just rule from the bench, but to review those matters and take my time with respect to judgment notwithstanding the verdict for you and Ms. Rivera. I'm happy to do that, but I do want to tell you that new evidence, I will not take up. I would only take that up in a motion for new trial. That would be a basis if there was new evidence and you could prove it to me that there was evidence of fraud or concealment, anything like that, and you could prove that to me, that would be a basis for a new trial. So that's what I mean by taking things in their proper order, all right? Right now, I'm going to review what he has with respect to judgment notwithstanding the verdict, and if I believe that the verdict could be supported based on what the jury heard and the evidence that was admitted during trial, then I will sign the verdict. I will sign the judgment, and then you have time to file a motion for new trial regarding new evidence that you received or that was revealed. Okay?
Understood.
That's the way it's going to.
Does the court need me to walk you through the standards for a judgment notwithstanding the verdict, or you're familiar with
I'm
them?
very familiar with it.
Thank you, Judge.
I just, when somebody asks me to please review what they have because they've filed a lot of things, I give them the consideration and look at those matters, okay? That's what I'm going to do. So do you have the judgment that you wish for me to sign?
We filed it, but I can get you the number so that Amber can forward it to you.
Okay, so I'm going to look at the judgment notwithstanding the verdict, and then I'm going to look at the judgment, and then after that, if I am signing the judgment, then I imagine that Mr. Ross will file his motion for new trial.
Thank you, Judge.
Ms. Rivera and I filed a proposed order for judgment as well.
Okay, very good, and I have your judgment notwithstanding the verdict, the order for it.
It's in the record. It
All right.
hadn't been accepted yet.
And now, is it separated between you and Ms. Rivera, or just together?
It's together, both signed by us.
All right, thank you so much. And
Thank
you
you,
are
Judge.
excused for the day.
Thank you, Judge.
All rise. Court is
All the copies of everything he made. Are you going to give them to me?
She doesn't want it.
we're done, I think.
She wants it for the motion for new trial, if that's what happens
But
next.
you need to.
You okay? You okay? Yeah. Have a good day.
You too.
You like Joe's haircut? Haven't seen you in a while. You look a little different.
I like your haircut.
No, it's not cut.
Oh, let me cut it.
No,
No.
thank you.
I'll just give it a little. I'll give you a bald. Past the zero.
Good to see you. Come on out.
A
We're done.
negative. I'll give you a negative.
We're done here.
Take care.
Take care, bro.
Yes, sir.
What's your life on?
Oh, I was just reading the back of the seats.
Oh.
Did you want the microphones off
They're all,
camera?
Everything in there.
all have these like little stickers on them.
Yeah, it's just the property of Bear, that's what it is.
Oh, sweet. Who owns Bear?
The Bear County, the Bear County. That's the property of the county.
Oh, okay, Bear County. Who's in charge of it, or like who's
The county,
So it's like nobody owns it.
yeah, the county, the actual county people, but it's the,
Excuse me.
it's the,
Thanks, Gabe.
basically Bear County is, it's its own entity, and that's who owns it. So, all you people are outside.
Okay, cool.
All right, take care, man.
Sweet. What's your name?
I'm Cowboy.
Cowboy. Sweet. My name's Cowboy too.
Yeah, it is.
Cowboy.
You better go catch your family.
Dundee. Take care.
All right.
Are these snacks?
Yeah, you can have a snack. It's still good. I don't know if they're still good, but you can open the one.